someone died 8 years ago, 10 years ago. I even had someone die 34 years ago, and no one changed the name on the house. So now the house is still in the name of someone who passed away all those years ago, decades ago. And the person who's it's been always been family living in it, and now great great granddaddy's name is still on the house, but I've been paying all the bills, and now I want to fix it up, but I can't get a loan because my name isn't on the house. Hi, I'm Ada Davis, the legacy attorney. I'm a licensed attorney and a certified estate planner. I build estate plans that create generational wealth and build financial legacies that will transform the trajectory of your family's financial success for generations to come, even if you don't have any assets. I know that when a loved one dies, sometimes we get caught up in the emotion and the grief, and it doesn't really occur to us that we have the business that needs to be handled. Ideally, you have drafted a will, you've placed your assets in a trust, or you have done something that lets people know how to handle your business so that it can be done smoothly. Nevertheless, no matter how you've handled it, no matter how you've sought to organize your affairs, or even if you didn't organize your affairs and now your loved ones have to go to the probate court or the surrogate court and figure it out for themselves, it's important that you, as a loved one of someone who has passed away, that you go and start that process as soon as possible. I can't tell you the number of people that I have had come to my office or call my office and tell me about someone died 8 years ago, 10 years ago. I even had someone die 34 years ago, and no one changed the name on the house. So now the house is still in the name of someone who passed away all those years ago, decades ago. And the person who's it's been always been family living in it, and now great great granddaddy's name is still on the house, but I've been paying all the bills, and now I want to fix it up, but I can't get a loan because my name isn't on the house. It just causes a lot of problems and a lot more issues than you need to if you were to deal with that immediately. Especially if you know there is a will, you need to probate that immediately. Some jurisdictions have a waiting period. The state of New Jersey requires that you wait 10 days before they will accept probate of a will or start an administration process. Every state has their own timeline. But once that timeline passes, you should start the process immediately, especially if you have a will. Because what you don't want is for people to think there is no will, or people to think that there is an older, people to only know about an older will or a different document. And then they process that document, they submit that paper to probate, and then your document is now, and you now have a problem. Because there's also a limit in most jurisdictions where you can only challenge a will for so long. In New Jersey, it's 6 months. You have 6 months, somebody submits a will to probate and you don't challenge that will, you're after 6 months, you run the risk of not being able to challenge that will, even if that will was not the last will or the valid will. So no matter how difficult it might be, always remember it is very important to start the probate process as soon as possible and to remove the name of the person who passed away from the assets as soon as possible. I know sometimes it might not be possible because that name is on the mortgage, and maybe the person who is inheriting the house can't afford to get a mortgage, or the credit issues and things like that are a problem. But do what you can, start the probate, and make sure that their person who has the authority to gather the assets and handle the business is designated as soon as possible, because you don't want to have to go into a court and explain to a judge why you didn't act. I had a call to my office the other day from someone who has a will that is dated 2021 that they never submitted to probate. And now they have found out that almost a year ago, other family members submitted a will to probate that was dated 2018. So the 2021 will very likely rescinded the 2018 will, but no one knew that. because the person who had the 2021 will didn't go to court, and the person who died 8 years ago. So you cannot allow these kinds of time frames to pass before you go to surrogate court and go to surrogate court and submit the paperwork, start the process, and make sure that the surrogate court is aware that of your desire to be appointed as the administrator, your selection as the executor in a will, the existence of a will. These are the kinds of things you got to get these things done.